So, welcome to Constitutional Law. Tonight, we are discussing the law of citizenship. So, citizenship in Ghana. So, we will first of all try and understand uh, the importance of citizenship at both international and municipal law. And then we'll look at the, the concept, the idea behind citizenship, historically and also philosophically. And we will come home and try and understand the Ghanaian law regarding who a citizen of Ghana is. And we also try and explore some uh, controversies which have developed on the issue of citizenship for quite some time now. And these are matters which all of us have been witnessing every now and again. And just before we proceed, as I have indicated, we are living in a very exciting times with the ongoing debate about constitutional reforms. What I propose to do is that I have settled on using the CRC report, Constitutional Review Commission Report 2010. I'm going to segment it and give it to groups for you to do a bit of like a mini project so that we will arrange and meet in the classroom and take your presentations on that. So that will be made available to you this week. So having said that, we come back to citizenship. And citizenship uh, has been described as the right to have rights, so to speak. What is that? Well, if you look at the very architecture of constitutional law, constitutional governance, or democratic governance, we talk about rights, but most of these rights can be enjoyed or are meaningful where you are a member in the formal sense of a political community or the democratic establishment. Now, where you are a member, then you are conferred with essential rights and duties. And this actually enables you to have capacity to claim protection from the state and assert freedoms within society. You will notice, or you might have heard of what they call the social contract theory or the social contract doctrine. Of course, they're attended by some political scientists or legal philosophers to try and explain why we have the states and the cities, why the state is able to exercise authority over us, and then what we as citizens should expect from the state. So that social contract, the ability of the state to exert, let's say, that the sovereignty over its citizens, and for citizens to also expect certain entitlements, including protection, is very much dependent upon this notion of citizenship, this membership of the political community in the formal sense. And that underscores the importance of this topic in constitutional law. So if you look at the literature, various writers, including our own very Professor Tukuba, Professor Kumado, Amino Aluka Otis, and also Benon, they all variously make the point that citizenship is the condition precedent for the full enjoyment of civil, political, economic, social, and cultural rights. And where you do not have citizenship, you are in a situation you call statelessness. So when you are a stateless person, that is to say that you do not have citizenship, because citizenship is attached to a country, is attached to a state. And for that matter, if you are doing international law, and I'm happy you are doing international law, if you look at the Montevideo Convention on Statehood, certain indicia or certain characteristics of what make a state was actually enunciated in that Montevideo Convention many years ago. And one of those requirements is that quite apart from having a territory, the state, must also have what? People, population, over which it exerts authority, as it were. So citizenship then becomes very important. Maybe just before we move on, because I'm a Christian and I also familiar with the Bible, where it is relevant, I try to relate it to what I'm teaching. So those of you who are familiar with the book of Genesis in the Christian Bible, I'm sure there may be a similar thing in the other Quran or the other holy books. So if you look at the book of Genesis, for example, you will notice that the story of Cain and Abel, the two brothers, one of them, they all went to make sacrifice to Almighty God, and I think the Abel's sacrifice was acceptable to God because it was properly done, and then Cain's sacrifice was not acceptable, and for that matter, Cain became jealous, and he also killed his brother out of jealousy or envy for his sacrifice, having pleased Almighty God. So later on, God encountered or met Cain, and Cain, suffering from guilty conscience, right? Like guilty mind of what he had done, killing the brother. He was worried that if God did not put protection on him, a cover on him, somebody will kill him. So if you read the story, I think a mark was put on him. Well, I'm interested in the analogy. So just for purposes of analogical reasoning, one will maintain or summarize that when Cain had actually killed his brother, he had become wayward. And maybe in modern sense, we probably say stateless, because he had lost the authority to be at where he was under the control of God and all that. Yeah, so statelessness is a very serious thing, meaning that you do not bear allegiance to any particular state. So that is serious. So there are a number of case law in which the importance of citizenship has been underscored, including the well-known case of Shalaby versus Attorney General. So if you look at Shalaby versus Attorney General, for example, from Benjamin J., as he then was, quoted the Chief Justice Warren's decision from Perez and Brownwell, and would, among other things, make the point that citizenship is humanity's fundamental entitlement. And he described it as nothing less than the right to have rights. So citizenship is your entitlement, and it is your right to have rights. So it is the key which you hold to unlock other compendium of rights. And that is true. So it is a threshold thing, as I indicated. You have it, then it opens doors for you to get other rights. Now, where you do not have citizenship, or where you've been deprived of citizenship, what it means is that you become a stateless person. You become a stateless person. Once you are stateless, you are also stripped of lawful protections, privileges, and claims. to state intervention. I'll give you a typical example. If you have, let's say, a passport of a particular country, that is obvious evidence that you are a citizen of that country, so to speak. Now, where you are in another jurisdiction and something happens to you, by reason of your passport, the government of Ghana will have to intervene because you're entitled to protection. If on the international plane, international arena, you are not being properly taken care of, the government of Ghana will intervene. So that gives you an idea of how important citizenship is and how dangerous statelessness is. Statelessness is not a good thing. It's a existential predicament, as it were, because if you're a stateless person, it is not only that you lack a formal bond to any state, but you also experience profound vulnerability in the sense that basic protection from exploitation, discrimination, I mean, to some extent, human rights abuses, because sometimes you may need a state actor to take up your grievance in certain international judicial fora, as the case may be. And that is why statelessness is not a good thing. Well, international law recognizes how important citizenship, and for that matter, nationality is. And that is why, if you look at the Universal Declaration of Human Rights, one of the major instruments to make a formal articulation of human rights and freedoms as understood in modern sense. Article 15 thereof will make the point that everyone has a right to nationality, and it adds that no one shall be arbitrarily deprived of his nationality, nor denied the right to change his nationality. So your nationality is protected. Of course, you also have the right to change your nationality subject to complying with the requisite framework, as the case may be. And that is why Justice Taylor would also point out the dynamic nature of citizenship. In the case of Fita against Minister of Internal Affairs, it's not being mentioned for the first time, because we mentioned it last semester when we were learning the other topics, including constitutionalism and all that. Now, Justice Taylor in Fata against Minister for Internal Affairs makes the point that citizenship is not merely a static or isolated legal event, but rather an evolving, continuous legal relationship. So citizenship is not static, but it's an evolving, continuous legal relationship. And so if we read that case, for example, Taylor will make the point that, Justice Taylor J. Accident will make the point that the existence or non-existence of citizenship is a continuous state of what? Affairs. And that implies that citizenship status, once acquired or lost, carries ongoing legal and practical implications that persist until legally modified. So, if you have citizenship, you don't just say that I have given it up. You have to comply with the requisite legal framework. And if for nothing at all, remember cases not too long ago, the Achekwesin case, just a minute, Zabate. Yes. Yeah, sorry. Yeah, so I mentioned the fact that if we can easily associate with the point Taylor J is trying to make in the Fatah's case by looking at the cases of Adamu, Sakande Adamu. Of course, the articulation is still, of course, the most important aspect about the citizenship, I think, is dealt with. But at least the implications of, not exhausting the requisite legal procedure for acquiring or giving up citizenship actually uh, reinforce the point that Taylor has made, that not until you have done it properly, uh, it will continue to persist. The legal and the practical implication continue to exist with respect to the particular citizenship that you hold, as it were. Again, it is that observation also brings out the need for citizenship law to remain adaptable, responsive to changing societal realities. For example, in Ghana, a lot of Ghanaians would like to go to other countries where there are better economic prospects in order to make money, send some back in the form of remittance, or come back to their country. It's something that we know. And so that being the case, should we not recalibrate our citizenship law in such a way that it will be responsive to these social realities? And so migratory patterns and other international obligations and national interests. So national interests, for example, if someone has a certain highly desired talent or skill, and the government of Ghana would like to keep that person to help national development or to further a certain national interest, the government may want to confer citizenship on that person so as to be certain of that person's allegiance. Yeah, so we discussed more about this history in the course of time. There have been a lot of scholarly debates regarding citizenship's dual character. So citizenship dual character here, I'm not talking about dual citizenship. We come and talk about dual citizenship, but I'm talking about the, if you like, the double senses in which citizenship is appreciated. One, has a right to have rights, as we saw from Chief Justice Warren's dictum, giving no local judicial imprimatur by Benjamin J., as he then was in Charlemagne as Attorney General. So it's a right to have rights, and then it's a dynamic legal status. Now, these two aspects have actually triggered interesting debates as far as the proper understanding or the proper conceptualization of citizenship is concerned. So modern theoretical approaches will highlight citizenship as comprising both rights. So that when we talk about citizenship, yes, then we must have in mind the right to vote, freedom of expression, political participation. So like these have become like the basic manifestation of citizenship, if you like. So that is one view. And then there's also reciprocal responsibilities. Of course, if you look at Article 41 of our own constitution, you notice that after saying that you're entitled to so many fundamental human rights and freedom in Chapter 5 of the Constitution. That is from Article 12 to Article 33. If you go to Article, I think, 41, we are told that as a citizen, you also have duties. So, reciprocal responsibilities, including civic engagement, taxation, military service, and national loyalty. You're a citizen, you have to pay tax. And I must say that one thing Ghana, we have to wake up to. And I think that our national institution, like the probably National Commission on Civic Education and Commission on Human Rights and Administrative Justice, I stand to be corrected. In my view, are probably not doing much in terms of inculcating the need for citizens to consciously pay taxes. There are many Ghanaians who don't pay taxes, although they earn income in various ways. Now, if you don't pay taxes, how do you expect the government to have revenue to fix the roads, to do so many things? It's not the time that we can go and beg other people. We need to be responsible. And that is part of citizenship. So I'm looking forward to the government evolving a very, let's say, simplified system which citizens can be encouraged to use to pay tax, and on their own they will quickly come forward and file their tax. It will get like a very simplified procedure, not complicated, and it will surprise you how much revenue will come from that. So some of the scholars who have engaged in this theoretical debate on citizenship include Onazi. Onazi argue for a balanced perspective and has cautioned against the contemporary emphasis on rights alone without adequate foregrounding corresponding civic responsibilities. In other words, he's just encouraging what we in Ghana have elected to do. Because we, and of course, not only in Ghana, you are doing international law. If you look at the African Charter on Human and People's Rights, you notice that unlike other international human rights instruments, we in Africa have actually noted that enjoyment of right goes with corresponding responsibilities or duties. And you see duties over there, just as we have in our constitution, as it were. But you can read more about this later on. Yeah, so we would like to look at the conceptual foundation of citizenship. Well, we have noted part already that citizenship as a concept is very central to political authority and constitutional law. And I mentioned not too long ago, even the Montevideo Convention on the indicia of the criteria for statehood. And for that matter, citizenship is a formal membership in a political community. At the core of citizenship is the idea that it confers upon the individual a bundle of rights, such as civil liberties, political participation, and access to state resources. And at the same time, impose reciprocal responsibilities toward the community, as we have noted, taxation, military, national service. And national service, for example, I should say that we should take serious. You never know when you'll be embarrassed for not having performed your national service. So our colleagues who will be jumping from one education to another without bothering to get their national service done. I'd like to encourage you as a friend that get it sorted because you never know when you will need it. At least so long as we've not changed the law and it's still part of our society, we need to satisfy all righteousness, as it is often said. Now, historically, uh, the idea or the concept of citizenship can be traced to ancient Greek. We've heard of Aristotle. Aristotle did this work, a book he called the Politis. Now, in the Politis, he wrote about ancient Greek Athens. Athens was like a city-state, and the city-states were called the polis, P-O-L-I-S, polis. Now, and you might have heard of the famous saying that man is what? A political animal. So when we say man is a political animal, that concept actually goes back to the idea of the polis, like polis. So Aristotle defined citizenship mainly in terms of active engagement in political and public affairs within the polis, within the city-state. So if you actively took part in the political and public matters in the polis, in the city-state, then you had citizenship. So therefore, to Aristotle, citizenship was fundamentally participatory. Citizens were those who contributed directly to governance through political deliberation, decision-making, and judicial functions. So therefore, we notice that in the classical Greek citizenship was the idea of active responsibility and not passive rights. And if you remember, either during one of the George Bush's speech and also our former president that I call on you citizens, I call on you to be citizens, not spectators. Citizens, not spectators. And that statement is quite profound. So that reflects this conceptualization you are talking about. If you remember, I said that I expect you to be citizens, not what, not spectators. So being a citizen means that you participate in political deliberation, decision making, governance, judicial functions, payment of tax, and so on and so forth. You are not supposed to be passive. And that is why, if you look at Ghana, for example, a lot of patriotic songs, Ghana ma yewala widio, menkase omfa ho, umaye nyina mum ye mum yemfa ba koye. No, those kind of things, you know the lyrics. So the point about Momai is just to reinforce the idea that citizenship requires active responsibility and not just passive enjoyment of rights, as it were. So let us keep that in mind. So if you are a citizen and you abstain from public affairs, of course, you are deficient, or your citizenship was not full. A citizen have not gone full cycle, or it is incomplete. And that underscores the fact that being active in civic role is inseparable from citizenship. So citizenship is inseparable from civic responsibility. They go hand in hand. Now, if you also come to Roman civilization, the Roman Empire, and I want to believe that you are familiar with the William Shakespeare's Julius Caesar. Julius Caesar's work, and it give you an idea of how important citizenship is. And of course, those of you who know the Acts of the Apostles in the Bible too, how St. Paul would actually talk about how he got his Roman citizenship. When he got to a time that they wanted to beat him without having actually given him a fair hearing, and how he accepted the Roman citizenship. And one particular governor also said that he even had to pay so much money to get the citizenship and so on and so forth. So it just tells you how citizenship was also important in the Roman Republic or the Roman Empire. So in the Roman Republic or Empire, citizenship evolved further to incorporate defined rights such as property ownership, legal protection, and participation in what? In public life. At the same time, citizenship remained deeply intertwined with duties. So just like we saw in the other, like the Greeks, civilization, military service, taxation, and civic duty, virtue, they're all supposed to be part of that which accompanied citizenship. So in the Roman Empire, understanding of citizenship emphasized allegiance, service, and loyalty. So these were seen as an integral membership of the political community. No wonder in Ghana, when we also have our own constitution, we have what they call like the oath of what? Allegiance. If we go to the second schedule of our constitution, I, so and so and so, do in the name of the Almighty God swear that I will bear true faith and allegiance to the Republic of Ghana as by law established, that I will uphold the sovereignty and integrity of Ghana, and I will preserve, protect, and defend the Constitution of the Republic of Ghana. So this oath of allegiance is actually a reflection of the things we're talking about as far as the citizenship is concerned. Now, beyond Roman Empire, when you come to that's the modern Europe or the modernizing Europe, we get to the Enlightenment era. I hope you remember your history. The Renaissance period, the Enlightenment period, during the time when there was so much emphasis on the use of the reason and also scientific inquiry or curiosity. Now, around that time, modern conception of citizenship began to crystallize through social contract theories like Thomas Hobbes, John Locke, Jean-Jacques Rousseau. And Hobbes, for example, in his work, The Levantine, published in the 17th century, will portray citizenship as emerging from a social contract wherein individuals surrender certain freedoms to a sovereign authority in exchange for protection and security. So you are giving some of your freedom so that you'll be, if you like, controlled by the state authority. But in return, you're also supposed to be protected from being harmed. You are supposed to be protected from somebody taking your property and so on. So for Thomas Hobbes, citizenship inherently involves obligation of obedience and loyalty to sovereign power. And that actually reflected the contractual balance between the state authority and the individual rights. Similar ideas were propounded by John Locke in his work, The Second Treatise, in which he also emphasized the reciprocal duties. The fact that citizens have the responsibility to respect others' rights, abide by laws, support governmental institutions financially through payment of tax. So actually, if you are a citizen and you don't pay tax, then I mean, there's a question mark about your citizenship as whether you are a citizenship in the true sense of the word. So actually, paying tax, you should not be chased. It should be something if your mind and heart are working well, and you understand what it means to be like a citizen, you yourself will take steps to go and pay taxes, as it were. So those of you here who are not paying taxes, I'm pleading with you to pay taxes so that your citizenship will be meaningful. Okay. We also have J.J. Rousseau. He also wrote this word, the social contract, the same ideas. And he made a point that citizenship is a collective participation in political decision, and pointed out that it is also a civic virtue, an active participation, which form the very foundation of citizenship. So at least we have seen how the concept or the idea of citizenship has evolved over the period, right up to the post-Second World War, when we had like the first major instrument, the Universal Declaration of Human Rights, which you mentioned, of 1948. And the Universal Declaration of Human Rights would actually articulate citizenship prominently in terms of human rights, and will position nationality, that is citizenship, as fundamental for accessing basic civil, political freedom, social services, and international protection. And that thinking has also influenced various development in Ghana, as we've seen, in our various constitutional provisions and also citizenship legislation. It reflects that thinking. So as we move on, you appreciate it. Yeah, so the debates regarding the whether rights and responsibilities go together in citizenship, they've been going on in the literature. So in your notes, we've made a reference to a lot of them. You just read them, but because of time, we just make progress. So just before we move on, we will just sum up with respect to the conceptualization bit of citizenship by saying that citizenship should be conceptualized and operationalized as a two-way social contract or two-way traffic, in the sense that it should be anchored both in robust rights and entitlements. The citizen should go with what? Robust regime of rights and entitlement of freedoms on the one hand, and at the same time, it should also be accompanied by civic responsibilities. And that is why we are saying that as a more, if you like, better way of conceptualizing citizenship is to look at it as a two-way social contract, as it were. So that citizens enjoy rights, they are beneficiaries of rights. At the same time, they are active participants in national development. Well, there's a few international law perspective on citizenship. From the point of view of international law, as we have noted not too long ago, citizenship is fundamentally understood as a legal bond. And I want you to pay, because this definition is from the Nottebohm case. You're doing public international law, so I want to believe that you're familiar with the Nottebohm case. So it is a legal bond having as its basis a social fact of attachment, a genuine connection of existence, interests and sentiments, together with reciprocal rights and duties. So that is how one of the early cases by the International Court of Justice, the case between the Liechtenstein and Guatemala, otherwise known as the Nottebohm case. That is how citizenship was explained. That is a legal bond having as its basis a social fact of attachment. So I want us to underline a social fact of what? Attachment. a genuine connection of existence, interests, and sentiments, together with reciprocal rights and duties. And now this foundational pronouncement by the International Court of Justice significantly shaped international jurisprudence and even how other municipal or national law will also deal with citizenship. But I will just say a few words about the Nottebohm case. The International Court of Justice was confronted with the critical question of whether citizenship granted by a state must be internationally recognized in all contexts. In other words, if Ghana has conferred citizenship on you, Mamiesi, for example, or Kweku Mensah, should Togo or Nigeria or United Kingdom or United States recognize the citizenship which Ghana has conferred on you? So that was part of the issue which the International Court of Justice had to address in the Nottebohm case. So the court ruled that international recognition of nationality requires a genuine link between the citizen and the conferring state. In other words, there should be, and that is why they said that if you look at the definition, they said that it's like a legal bond having as a basis a basic social factor of what? Attachment, a genuine connection of existence. So citizenship should not just be literal. There should be a genuine link between the citizen and then the conferring state, the particular state which is giving the citizenship. There should be that kind of connection, some link with it. Well, as we look at the facts of that case, you will come to appreciate that the decision was influenced by factors such as habitual residence, meaningful attachment, cultural affinity, economic interest, family ties, and active participation in civic life. So this approach aimed to prevent what they call nationality of what? Or convenience, or what they call the marriage of convenience now. Those who like to get citizens from countries where marriage, for example, enable you, people enter into fake marriages with citizens of those countries so that they will get it. I mean, that is the kind of thing Nottebohm case wanted to discourage. Or what we call sham citizenship. So where individuals seek nationality for instrumental or strategic reasons, without genuine social, cultural, or emotional bonds to the granting state. And for that matter, the International Court of Justice held that while states retain sovereignty in determining who their citizens are under domestic law, the international law validity and enforceability of nationality must reflect genuine connections and substantive affiliation. In other words, yes, as a sovereign state, you can decide however you want to confer citizenship, right, within your municipal legal system. However, if something happens on the international plane and you want to assert some protection, or you want to take up a claim on behalf of, let's say, a particular individual on the basis that that individual is your citizen. Now, at that point, the requirements of your domestic law will not be conclusive of the matter. And that is where some of the teachings of the International Court of Justice in the Nottebohm case will become more important. So among other things, for example, is there a genuine link between you, the conferring state, and the particular person you are trying to assert citizenship or nationality over on the international place? So those are some of the things. So if you look at the res factual metrics in the Nottebohm case, Nottebohm was a German by birth. He lived in Guatemala for 34 years and then retained his German citizenship and family and business ties with it. So he left his country, Germany, and living in Guatemala for 34 years. Now he applied for Liechtenstein citizenship a month after the outbreak of the World War II. World War II broke out in 1939. And Nottebohm had no ties with Liechtenstein, but intended to remain in Guatemala. The nationalization application was approved by the Liechtenstein, and there was implied waiver of even 3 years, because under their law, there was a need for you to have met a 3-year requirement, but that was all waived. After this approval, Nottebohm traveled to Liechtenstein, and upon his return to Guatemala, he was refused entry because he was deemed to be a German citizen. Of course, if you're a citizen of a country, you can move in and out anytime. When I'm going out of Ghana, I don't need to give anybody reason. When I'm coming back, I don't need to give anybody reason. But if I'm going to visit, let's say, United Kingdom, I'm going to visit probably other countries, I may be asked, what are you coming to do? When are you going back? Because I'm not a citizen of those countries. So that was the situation in the Nottebohm case. So his Liechtenstein citizenship was not honored, and that is why he was refused entry. So Liechtenstein filed a suit before the International Court to compel Guatemala to recognize him as one of its national. Now, Guatemala challenged the validity of Nottebohm's citizenship and the right of Liechtenstein to bring the action and allege its belief that Nottebohm remained a German national. I just want you to see like the fact, just because we said that there should be social basis of attachment or genuine link. If you look at how this particular person is spread, I'm sure you've read this international law already. We don't need to belabor the point. So, must nationality be disregarded by other states where it is clear that it was a mere device, since the nationality conferred on the party is normally the concerns of that nation, as we have been making? Well, so if you look at as we've seen the decision of the International Court of Justice already, that it is not what your internal law says, but as whether we can get the genuine link or the genuine bond or connection, as it were. So in this particular case, there was no genuine, there was no relationship between Liechtenstein and Nottebohm. And the change of nationality was merely a subterfuge, which was necessitated by the war. And for that matter, Guatemala was not forced to recognize its citizenship. So as I've indicated, this decision of the Nottebohm case has had a reverberation in various municipal legal system, and as people try to adopt a constitution. And we are not doing international law, but you have come across the Convention relating to status of stateless persons and the 1961 Convention on Reduction of Statelessness. And all those international legislative instruments have created specific legal obligation for states aimed at preventing and mitigating statelessness and arbitrary deprivation of what? Of nationality. And they also underscore the fact that citizenship determination by states must align or must be in accordance with international norms to ensure that individuals are not left without legal protection or rendered vulnerable to serious human rights or violations. I think we were here some time ago. Some people were said to have been killed. I mean, Ghanaians were said to have either been killed or handled in Gambia and also Libya. And you remember how our government at the time sought to take up those matters because of what? Citizenship. Yeah, so we will just leave the international discussion and come to look at, so how do we acquire citizenship under Ghanaian law? Well, under our law, citizenship is governed primarily by Chapter 3, which you have read and you've done quiz on. Maybe just for your information, at the next week, we have the outstanding quiz in addition to lectures that we do. So if you've not been reading the rest of the provisions, you should be reading it. I mean, the Constitution. And further to the Chapter 3, we also have various legislation. The very first one, the Citizenship Act of 2000 at 591, and the Citizenship Regulation LI 1690. And of course, there's amendment of the this particular provision too. And what they do is that they try to provide the various modes by which you can acquire citizenship. We are going to look at them. So the key methods of acquiring citizenship in Ghana include A, citizenship by birth and parentage. What we call the use, if you like, a sanguinis, for example. A use sanguinis means that blood, if you like, relationship or descent. So the primary mode of acquiring citizenship in Ghana is through descent, and that reflects the traditional principle of jus sanguinis, the right of blood. Now, the opposite or the contrast of jus sanguinis is what we call the jus soli. Jus soli. So, jus soli here means that you are born on the particular soil or the territory. Like the United States, for example, where mere birth within the national territory automatically confers citizenship. Ghana is not like that. By being born in Ghana does not automatically make you a Ghanaian. You must also satisfy the descent or the lineage. Of course, the United States, you remember under the current President Trump, they have been trying to change the jus soli because they've also seen that it brings about citizenship of convenience. People will get pregnant in any part of the world, and then when they are ready to give birth, they will try and go to the United States of America and give birth. They don't pay taxes and all that. Meanwhile, they would like the government of the United States to exercise protection over them. So all those, I think they are going to change. So if you look at Article 6 of the Constitution, particularly clause 1 to 2, as we have noted already, it makes the point that a person is a Ghanaian citizen if at birth, if they are born either within or outside Ghana to at least one parent or grandparent who is a citizen of Ghana. So if you are born outside Ghana, but we can show that one of your parents at the time of birth or one of your grandparents was a citizen of Ghana, you are a Ghanaian, you are a citizen of Ghana. And the same is the case if you are born even within Ghana. So look at the, read the whole of the Citizenship Act. It's not plenty. Just spend time and read them. So what these provisions means is that birth alone on Ghanaian soil or territory does not automatically confer citizenship unless it's accompanied by descent, as we have seen. Well, historically, the literature will tell us that Ghana's reliance on jus sanguinis rather than jus soli in determining whether Ghanaian citizenship has been attained reflects a deliberate policy designed to maintain strong cultural, familial, and historical bonds among Ghanaians, including those in the diaspora. So, for example, if somebody is in Jamaica or the US, we can show that, oh, I was born in Jamaica, I was born in the Caribbeans, but then one of my parents was a Ghanaian. It doesn't matter that he's never been to Ghana, he's a Ghanaian, as it were. But of course, if you also look at it from a broader perspective, by using jus sanguinis rather than the jus soli, one would argue that it's in harmony with the relatives of our contemporary Ghanaians, particularly those who live abroad. Those who reside abroad, they give birth over there. Their children maybe live outside for about 30 years, but so long as at the time that they were born, their parent, one of them was a Ghanaian or grandparent, they will still be Ghanaians. So if you look at it, it works well for our people who like to travel. But of course, we've had a problem in trying to prove as whether you are Ghanaian by birth. And you all know the case of NDC against Attorney General Electoral Commission 2020. I'm talking about one of the electoral register compilation cases and the controversy that it generated. As you remember, the Supreme Court caused a bit of like a stir for a lot of for people, other Supreme Court watchers, when the decision essentially said that Ghanaian birth certificate alone is not sufficient to conclusively establish Ghanaian citizenship, because it does not inherently prove parental or grandparental nationality. What do you think? Before I continue, let me take one or two thoughts. What are your thoughts on how the Supreme Court reasoned regarding inadequacy of a birth certificate in proving that you are a Ghanaian citizen, especially by birth? Yeah, raise up your hand and then I'll allow you to speak. Okay, Samuel.
Thank you so much, Your Highness. Yes, the issue of citizenship has been a very complicated one, because I quite remember when our ex-president was coming to power, he asked a question who a Ghanaian was, and it was he just someone who holds a Ghanaian passport or a birth certificate? And the answer to that question has not been clear, even in the Constitution itself, in a sense that we recognize ancestry as in the origins of your grandparents or your parents to determine Ghanaian citizenship. But anybody at all could come to Ghana as a family and have kids. I mean, anyone, who is not a citizen. Foreigners, let me put it that way. Foreigners can come to Ghana and in the course of their stay in Ghana have kids. And because these kids were born in Ghana, on Ghanaian soil, in Ghanaian hospitals, they are issued with birth certificates at birth. So can we call such people who bear Ghanaian birth certificates as citizens? Obviously, we can't say they are citizens because they hold Ghanaian birth certificates. And that's because their parents are not citizens, neither are their grandparents Ghanaian citizens. So I think I agree with the ruling.
All right, Samuel Amano, at least you've justified your position. Your position is, well articulated and coherent. Yes. Any other view? This is a class. We are students of the law, so don't be afraid of expressing a view. When I come here, I'm learning. When I leave the classroom, then I'm something else. But here we are learning, so just feel free and express your view, okay? Okay, you don't want to speak, right? Meaning that you agree with the position which our friend has explained beautifully. Okay, that's good. Yeah, those who have difficulties with the decision, or among other things, argue that the decision complicates citizenship verification, particularly when it comes to voter registration. But if you read that case, the court, speaking through Justice Professor Cote, would actually make the point that if you look at the history of compilation of the voters register, like birth certificate alone has never been a means of verifying an identity for purposes of registration. And if you read the judgment, that points come out. And if that is so, then it will validate the explanation our friend Mr. Mano gave not long ago. So I have taken a set from the decision and put in the notes for you. So from the, Professor Kote gave like the opinion on behalf of the court, and he, like I just quoted, this is a direct quotation. You can read it, because of time, but I'll just jump to. So, for example, somewhere in the judgment, as a Professor Kote will write, and I quote, "We find no merit in the." Okay, maybe before to make sense, let's go up. So, so this is what the landed justice of Supreme Court said, quote, "These anomalies in the 1995 and 2012 registration exercises were carried through into the 2016 registration exercise because both CI 72 and CI 91 provided for the use of existing voter identification card as a document for the identification of a person who applies for registration as a voter. It is a resultant situation which led to the Abu Ramadan series of cases. The issue in controversy in these cases was the constitutionality of the use of national health insurance card as evidence of identification of a person who applies for registration as a voter. Then you mentioned in Abu Ramadan number 1, this court held that upon true and proper interpretation of the right to vote, as enshrined in Article 42, the use of the national health insurance card as an identification document by regulation was inconsistent with and contravention of Article 42. And he went on with the relevant part, which I'm interested in. The section 3.4 of the judgment on the constitutionality or otherwise of non-inclusion of birth certificate So this is how the learned justice rendered himself, quote, "The second plaintiff contends that the non-inclusion by CI 126 of birth certificate as one of the documents to be used for identification of a person who applies for registration as a voter is in contravention of and inconsistent with the Constitution. We leave 3 and 4 endorse on the second defendant's writ for a declaration that Regulation 13 of CI 126 is inconsistent with and violates Article 42 and 45 to the extent that it excludes birth certificate issued to Ghanaian as a mode of identification and no establishment of qualification to be registered in the register of voters. Now, eventually, we'll make the point that it's null and void, that we find no merit whatsoever in the second defendant's contention. It flies in the face of Article 42 of the Constitution and the decisions of this court in Abu Ramadan number 1 and Abu Ramadan number 2. A birth certificate is not a form of identification. It does not establish the identity of the bearer. I mean, a lot of people were scandalized by this. Nor does it link the holder with information on the certificate. Quite obviously, it provides no evidence of citizenship. It therefore does not satisfy the requirements of Article 42 of the Constitution. In fact, as a form of identification, it is worse than the NHI card, which was held to be unconstitutional as evidence of identification of a person who applies for registration as a voter in Abu Ramadan number 1 and number 2. Yeah. Then he will explain what he means by identification. But the bottom line, trying to say, is that birth certificate is not enough proof that you are a citizen. It may be one of the materials out of which we may infer that you are a citizen, but that ipso facto is not sufficient. Another mode of having Ghanaian citizenship is by marriage and registration. So citizenship may be acquired by foreign spouses married to Ghanaians through process of registration. So if you look at Section 10 of the Citizenship Act 2005-91, a foreign national married to a Ghanaian may apply to register as a Ghanaian citizen, provided they satisfy certain conditions. So specifically, the applicant must demonstrate good character. So maybe you have to get a police criminal reference certificate, and maybe get testimonial from people who know you, that you're not a troublesome person, and provide evidence of genuine marital relations. So citizenship obtained through marriage registration remains valid even after the dissolution of the marriage. So whether by divorce or by death, once you acquired it, you've acquired it. Of course, there's wisdom in this provision as it ensures citizenship stability for foreign spouses. If that were not to be the case, their Ghanaian counterparts will use citizenship as a weapon. So citizenship will become a weapon in the marriage to arms twist the foreign partner. So I think there's some wisdom in that. Now, that notwithstanding, if you look at Section 10, subsection 7 of the Citizenship Act, Act 591, the Minister for Interior has discretionary power to scrutinize and verify application for citizenship by marriage, primarily to prevent abuse of the system through marriages of convenience or fraudulent marital arrangements. And of course, if you go to other countries, if you want to marry and acquire citizenship, you also do the same thing. I know some countries will even come and conduct a background check to find out that the said marriage is not a fake or a sham one. So if you're an applicant, you want to get citizenship under this mode, you must demonstrate that the marriage was contracted genuinely without the primary intent of gaining what? Citizenship. Of course, it's both subjective and objective in making such an assessment and determination. Now, apart from marriage, citizenship may also be acquired by naturalization. And that is another pathway for foreign nationals. So if you look at section 13 of Act 591, applicants seeking naturalization must meet stringent criteria designed to ensure meaningful integration into Ghanaian society. So what are these criteria that those who want to acquire citizenship by naturalization, or those who want to naturalize, what must they meet? Among other things, a minimum residency requirement of 5 years of continuous legal residence in Ghana. Under special circumstances, a shorter period may be accepted. Good moral character, so you must have no criminal record. So on this particular point, this is a good moral character. If you are doing company law, you have come across the case of Derek Edujamfi against the Attorney General, which is to the effect that in the Companies Act, where previously there was a provision that if you are charged with a crime or offense involving dishonesty and so on, then by reason of being so charged, you're disqualified from being appointed a director. The Supreme Court took the view that if you look at the constitutional presumption of innocence in Article 19 of the Constitution, such a provision which seeks to impose a legal disability on a person merely for having been charged with a criminal offense involving dishonesty or fraud is not constitutional, and same was actually struck down as being null and void. So on that basis, where there's a requirement that you want to apply for citizenship by naturalization, you must be of good moral character. I would like to think that on authority of the Supreme Court decision in the Derek Edujamfi against Attorney General, mutatis mutandis, one would say that if a person has been arrested and is charged with offense, but the criminal procedure has not actually terminated for conviction to be made, for his guilt to be pronounced, then such a person cannot be said to be lacking good moral character for purpose of maybe applying for naturalization. Again, the applicant must have the ability to speak and understand at least one indigenous Ghanaian language. Either you can speak Dabani, Wale, Ewe, Ga, Asante, Fante, just name it. There should be evidence of significant integration and commitment to contributing positively to Ghanaian society. So significant integration, of course, you must show not only that you can eat fufu or you can eat apple or banku or tuzafe or hausa koko. You must also show some commitment to contribute positively to Ghanaian society. So when you are successful, then you are issued the certificate of naturalization granted by the Ministry of Interior when same has been approved by the President. Of course, as part of the process, you go and swear the oath of allegiance, as it were. Now, if you are a naturalized citizenship, in terms of the bundle of rights and responsibilities which you are entitled to, it's very much similar to having acquired your citizenship by birth, except just a limited instances. For example, when it comes to eligibility for certain public offices like president or vice president, if you look at the constitution, if you want to be a president, you must be a Ghanaian by birth, as it were. Especially a president, vice president, being parented, like the descent will suffice. But if you're a naturalized citizen, if you're a naturalized citizen, then you cannot run for these high positions. Of course, naturalization indicates that we are open to integrating foreigners who genuinely commit to Ghana's social, economic, and cultural fabric. We also have citizenship by adoption and funding. So, adoption, if you look at Article 6, Clause 4, and also Section 9 of the Citizenship Act at 591, a child aged 16 years or below who is legally adopted by a Ghanaian citizen automatically acquires Ghanaian citizenship by virtue of that adoption. So long as the person you're adopting is 16 years or below, after going through the adoption procedure, automatically the person will acquire Ghanaian citizenship. And this is also very useful. That is to say that once, of course, adoption is for you to become the legal child of the adopting parent. So to be quite odd, the adopting parent, let's say there's a Ghanaian, and you two have a different what, nationality. We also have fondling. So if you look at the Constitution, Article 6, Clause 3, I think, and Section 7 of the Citizenship Act, for example, a child of not more than 7 years of age found in Ghana whose parents are not known shall be presumed to be a citizen of Ghana by birth. So that is the fondling. So if you are below 7 years, or you are just 7, your parents are not known, then you are called a foundling. And for humanitarian reasons, you don't want to be classified as a stateless person. So you are given Ghanaian citizenship. Of course, this is a presumption, isn't it? This is a presumption that you are presumed to be like a citizenship by birth. So if you are presumed to be a citizen by birth, what it means is that you could become a president of Ghana. We also have citizenship by presidential award. If you have, if you look at Section 14 of the Citizenship Act, if you have distinguished yourself or for some legitimate causes, the president can confer honorary citizenship on you. And if you take somebody like, I think there's Mandela, he acquired many of such citizenship. But to be eligible for this honorary citizenship, you must meet specified eligibility criteria, including good moral character, substantial contribution to national interests, the ability to speak at least one indigenous Ghanaian language, and an intention to permanently reside in Ghana. Now we have the controversial one, dual citizenship. And this came about as a result of the Constitution of Ghana Amendment Act 1996 at 527. Now, this amended the Constitution to expressly permit dual nationality. And that is to say that if you're a Ghanaian, you may at the same time or concurrently hold citizenship of another country. Of course, certain restrictions may exist in some cases, particularly when it comes to offices, which you can hold by reason of being a dual citizen. We have positions which have been outlawed as not being positioned that people who hold dual citizenship can actually occupy. And recently, the Osei-Bonsu case. We'll talk about it in a minute. And also the Asare against the Attorney General. Of course, there are so many Asare against Attorney General. We are talking about the dual citizenship case, in which the Supreme Court sought to clarify the rights of dual citizens and also the administrative requirements such as compulsory dual citizenship certificate or green cards, which cannot lawfully deprive dual citizens of inherent citizenship right. That if you're a dual citizen, you go and tell us an American green card, it does not mean that you have disabled yourself from enjoying certain rights and entitlements, which Ghanaian law says that you can enjoy by reason of being a dual citizen. Of course, we had a number of debates concerning the scope and limitation of dual citizenship. And there's been even a private members bill seeking to get the law amended for broader rights for dual citizens, including eligibility for more public offices. We'll talk a little bit more about dual citizenship and the recent decision of the Supreme Court, which said that the Citizenship Act, right, which included certain offices as being part of category of offices which dual citizens cannot occupy, when the Supreme Court strike it down as being unconstitutional. And people should understand it well. Supreme Court, they don't have any problem with inclusion of those things. But what the Supreme Court was saying was that to do that, you need to amend the Constitution, because those things have been listed or have been provided in the Constitution as being offices which cannot be occupied by, let's say, those who hold a dual citizenship. So therefore, if you want to add to the list, you must do the needful. You must do the needful by going through the proper procedure for amending that particular aspect of the Constitution, no more, no less. So that is what the Supreme Court was saying. But people misconstrued the Supreme Court to say that, oh, they are doing that because they want to favor a particular person to be appointed as Supreme Court judge, and so on and so forth. I mean, that was a very, if you like, a very limited way of looking at it. But they will say that yes, Parliament can go through the requisite procedure and include so many offices which a dual citizen cannot aspire, but the proper procedure should be followed. Just like what they did in the Abdullah case. This is Abdullah's case. Well, just before we move on, just a quick, we've done a lot of history this semester. And that is why I decided to bring the historical development of citizenship laws in Ghana into the middle of the discussion rather than bringing it at the beginning so as not to kill your appetite. I know some of you don't like history, but history is very important. So our citizenship law has a very long story which needs to be told, going back into the colonial era through the independence era and then the various military interventions. So if you look at the pre-independence or the colonial era, that is pre-1997, we were not, if you like, an independent country. So if you were a citizen of Gold Coast, you were a citizen of Britain, as it were. You're British, so to speak. So citizenship prior to Ghana's independence in 1957 was determined according to British nationality laws. So if you look at Professor Bennon's work, Constitutional Law of Ghana, you make the point that the colonial citizenship regime divided individuals into two broad categories. So we had British subjects, and these were persons born within British territories or dominions who descended directly from British parents. So being a British subject conferred certain privileges and rights, including freedom of movement within British colonies, protection by the British Crown, and eligibility for certain public offices. So this was the situation during the colonial, the pre-independence era. Then we also had aliens or non-British subjects. So individuals who were neither born within British territories. If you say British territories, it included the colonies and the protectorates and the dominions. Nor descended from British parents were classified as aliens. Of course, they're not talking about aliens from Mars or from Jupiter. So aliens were granted significantly fewer rights and were amenable to strict controls regarding residency, where they could, how long they could remain, movement, and economic activities. And they also had a limited protection from the British colonial authorities and could be deported without serious procedural guarantees. I mean, just today, for example, I read something in the news. I don't know if it is true that I think the Ministry of Interior is saying that foreigners who are involved in, I don't know whether galamsey or some criminal activity, the state will not waste its resources on them, and they will just be deported. So maybe similar to what we are discussing. Now, the British Nationality and Status of Aliens Act 1914, which was subsequently modified by the British Nationality Act of 1948, defines citizenship during the colonial period by emphasizing allegiance to the British Crown. So the litmus test was whether you owed allegiance or you bear allegiance to the British Crown. So within that context, citizenship criteria primarily operated on principles of territorial birth, that is the jus soli. Were you born in the British soil? And parental nationality, jus sanguinis, albeit within a distinctly colonial framework, which emphasized subordination and allegiance rather than reciprocal rights and responsibilities. So that was the situation. And this history is important because we never know when there will be a case in which nationality of a party may be necessary in resolving a particular issue before the case can be disposed of. Now, what was the situation as far as Ghanaian citizenship is concerned upon attainment of independence? So from 1957 to 69, 69 is like a watershed because when we had the Second Republican Constitution, we had a little bit more sweeping prescriptions as far as citizenship is concerned. So we want to look at the situation from independence up to the beginning of the Second Republican Constitution. So we had the Ghana Nationality and Citizenship Act, a 1957 Act 1 of 1957, which was enacted to establish clear criteria to define who will become a Ghanaian citizen following independence. So now it's no longer referable to the British nationality law. We must define who is a Ghanaian citizen. So under that legislation, citizenship by birth was granted to individuals born within Ghana who were British subjects or British protected persons at independence, provided at least one parent or grandparent was born in Ghana. Of course, it's the same idea which has been carried on into our current legal regime. Now, citizenship by descent also extended to persons born outside Ghana to Ghanaian parents. And if you look at it, there was a remarkable departure from the colonial era British nationality legal framework. Particularly, our new regime trying to prioritize lineage. That is a descent-based criteria, and not just being a colonial subject, as it were. Of course, our legislation was an attempt to foster nation building, achieve cohesive national identity by clearly defining membership of the newly independent Ghanaian society or polity. And of course, our concerns and priorities will be different from the concerns and priority of the colonizer. Now, what about the situation from 1969 to 1992? There was increasing emphasis on the jus sanguinis, as it were. We've had the 1969 Second Republican Constitution, the various military intervention, which we saw last semester, and then the Third Republican Constitution of 1979. And all these phases of governance in Ghana had implications for how our law on citizenship evolved. So there were regular revisions of citizenship law, and the revision tend to increasingly reflect the jus sanguinis principle rather than territorial, but that the jus soli. So, for example, you look at the Ghana Nationality Decree, NLC Decree 333 of 1969, it restricted citizenship by birth significantly by requiring proof of Ghanaian parentage and lineage rather than mere territorial birth. So it's not enough for you to say that I was born in Ghana. No, you must show they do have a descendant who was a Ghanaian. And this was important. I'm sure you have heard of what we call the Aliens Compliance Order. The Aliens Compliance Order, as it were. So it was necessary to build national cohesion, immigration, check immigration, and also advance internal security. Then we also have the Ghana Nationality Act of 1971, Act 361, which further reinforced lineage-based citizenship and continued to reduce reliance on territorial birth alone. So consistently, the emphasis now was that to have citizenship, you must have at least one parent or one grandparent who was demonstrably Ghanaian by birth or descent. So we're having more lineage focused policies, which were aimed at managing migration flows and also addressing demographic shifts, which resulted from regional political upheavals. Of course, around that time, too, the military intervention and other upheavals were taking place within the sub-region. So if we had not, for example, been a bit more insistent that it's not enough to have been born in Ghana, we are going to get so many people accepting Ghanaian nationality without any serious blood relationship. Okay, we've talked a lot about the Fourth Republic and then the 1992 Constitution, all the modernization, and of course the dual citizenship, which has been introduced. So we not belabor the point. If you look at how citizenship by birth and parentage is attained, we talk about the dual citizenship Constitutional Amendment Act. Maybe just a few more words about that, because that is something which is very important to us as Ghanaians. Ghanaians are not going to stop traveling today or tomorrow until maybe Ghana has become so prosperous that probably if you are working here, if I'm working in Ghana, for example, I can earn $5,000. I can earn, $3,000, $4,000, $2,000. Why do you want to go and stay in somebody's country? So maybe in the course of time, as we get more and more developed and there's more prosperity, maybe people will now find it less and less incentivizing in traveling. But not until we get there, Ghanaians will continue to see greener pastures. So we need to be interested in issues of dual citizenship. And that is why we had originally the Constitution prohibited dual citizenship, but subsequently we did amendment in 1996, just barely 3 years after the Constitution has come into force, to recognize dual citizenship. But as we've noted, there are some offices where it's a no-go area if you're a dual citizen. And being a president or members of parliament, ambassadors, security chiefs, and senior judicial position, especially the Supreme Court judge and then the Chief Justice. If please, everyone must download Citizenship Act 2005-91 and look at the whole of the legislation. We discussed Asare and Attorney General. Yeah, so there's a case I want us to look at. That is the Francis Osei-Bonsu against Attorney General just last year, and around February or March or thereabout, where the Supreme Court revisited the dual citizenship rights, particularly the statutory extension of positions excluded to dual nationals. Now, if you look at the Constitution, I just skip it because of time. So if you look at the law, specifically if you're a dual citizen, you are explicitly debarred. You are prevented from occupying the position of president, vice president. You cannot be MP. And you know the Achikwesin's case. That is part of it. And also Adamu Sakandi and similar cases. Like if someone had like a dual citizen, whether the time the person filed to be an MP sought to be elected had the person actually relinquished the dual citizenship. Those are some of the issues. Then, Ambassador, High Commissioner, Chief Justice, Supreme Court. Of course, if you are not in the Supreme Court, it means you can be a dual citizen, but if you want to be in the Supreme Court, you have to relinquish that. Chief of Defense Staff, Service Chiefs, IGP, Director of Immigration Service, Heads of Security Agencies, and senior public servant. Now, this one, some of these, including the Supreme Court judge, have been struck down by the Supreme Court as being unconstitutional in Francis Osei-Bonsu against Attorney General. And why did the court say that? Justice Kulindi read the judgment of the court, and I have taken excerpts from his judgment. Let me just put them in the red. So if you look at his judgment, and I want all of you to read it. It's an interesting judgment. So he was making the point that I'm just quoting from his judgment, the red one. A cursory perusal of Article A2, to Justice Kulindi speaking, a cursory perusal of Article A2 against Section 16, subsection 2 of Act 591, that is the Citizenship Act of 2000, evidently reveals that 7 new offices have been added to the list of offices originally under Article A2. To say that if you go to Article A2, the framers of the Constitution have listed positions that you cannot actually hold if you hold the dual citizenship, as it were. So the first question with which we are therefore concerned is whether this insertion of additional offices to the original list encapsulated in Article A2 amounts to an amendment of the Constitution. It is settled and tried that in interpreting the constitutional provision, the national ordinary meaning must first be accorded. I mean, it goes on, blah, blah, blah. He just cite but the relevant part for us. And so he tries to make the point that if you look at the Constitution, there's an amendment framework, okay, procedure for amendment, Article 289, for example, and he will quote that and make the point that we agree with the plaintiff and Attorney General that the effect of Section 16(2)(a), which restrict dual citizens from occupying the office of Chief Justice and Justice of the Supreme Court, amounts to a non-constitutional amendment of Article 1284, as it imposes a further qualification criteria which was not contemplated or endorsed by the Constitution or persons who are serving as justices of the Supreme Court. This backdoor attempt to impose a further qualification criterion on members of the APES falls foul of not only the principles of procedural constitutionalism, by reason of the Act's failure to be passed in accordance with the prescriptions of Article 289 and 291, but also of the substantive test of Constitution, as it is directly inconsistent with the scope of the criteria set out in Article 1284. So you're just trying to make the point that if you look at the Article 1284, we are told who qualifies to be a Supreme Court judge. And this is what it says. A person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer. So my Lord Kulindi just was trying to make the point that if we look at Article 128, Clause 4, there is no inclusion on the fact that you must not be a dual citizen. And for that matter, if Parliament has included, being a justice of the Supreme Court in the list of those who are not qualified, I mean, in the list of those positions which cannot be held by a dual citizen, then the Supreme Court, as it were, is trying to amend Article 128, Clause 4. And that is not the case that it cannot be amended, but there's a proper procedure for amending it. So if you look at Article 289, there's a procedure for amending that. So you have to go through, I mean, it's an entrenched provision. You have to go through that procedure before you can amend it. And you cannot use any other procedure. So the reason he used in this case is consistent with the view he expressed in the case of the Justice Abulai against the Attorney General. So please read it. So just I will skip something for you to read the notes. So loss of citizenship. Citizenship can be lost through clearly defined circumstances. So it can be lost by revocation. So here, involuntary loss is taken away from you. Particularly so if you acquired it through registration or naturalization, it can involuntarily be revoked by the state. So if we look at the Section 18 of the Citizenship Act of 2005-91, among other things, where you committed fraud or misrepresentation in getting the citizenship, that can be a basis for its revocation. So where does a deliberate deception, false representation, or fraudulent concealment of material facts, such as hiding a criminal records, or falsely claiming Ghanaian lineage, or forging documents, it can all result in revocation. Also, activities inimical to national security. If you are not a citizen, by descent, and you engage in actions seriously threatening Ghanaian national security, such as espionage, terrorism, treason, or subversive activities intended to destabilize, overthrow the constitutional order, then your citizenship can be revoked. Of course, activity prejudicial to public morality or interests in appropriate cases may also be. But of course, if you acquired by registration, then you could loosen it under appropriate circumstances. But if it's by descent, in terms of having one of your parents being a Ghanaian, you cannot have your citizenship revoked. Yeah, so of course there are safeguards. You can go to the High Court. The Attorney General can go to the High Court to request for revocation. An affected person will be notified of the charges and evidence against him, and he can also put up his defense for the court to adjudicate whether a case is made for the person's citizenship to be revoked, as it were. So please read all this. Of course, when your citizenship is revoked, it goes without saying that you lose all your citizenship-related rights, voting rights, eligibility for public office, diplomatic protection abroad, and unrestricted residency. Now, you need a visa or you need a residence permit before you can stay here because you are no longer a citizen. We also have voluntary renunciation. This one, not revocation. So you are freely renouncing your citizenship. That can also be done by complying with the requisite procedure. So if you look at the Section 17(1) of the Citizenship Act, a citizen who voluntarily seeks to relinquish Ghanaian citizenship must formally declare their intention through a prescribed statutory form to the Ministry of Interior. Then the declaration must explicitly confirm that the individual understands the legal implication and consequences of citizenship renunciation. So once it's submitted, the declaration will be registered by the ministry, evidencing the fact that you have formally documented your loss of citizenship. So when it's successfully done, then you cease to be a citizen of Ghana. And consequently, you lose all rights and privileges which go with being a Ghanaian citizen. So let us keep that in mind. Of course, number of situations may prompt renunciation. Either you acquire citizen of another country, and that country prohibits dual nationality. Some countries will not entertain you having dual nationality. So maybe you definitely want to get that nationality. You may have to lose your nationality. Or seeking political office, or maybe security sensitive employment in a country that does not permit dual citizenship. Let's say you want to work in the NASA, for example, assuming you're a top scientist. They certainly will not be happy you being a citizen of another country as well. They want a complete loyalty. Now, you can reacquire citizenship following renunciation. It's possible under appropriate circumstances. Okay, so I will draw the curtain down here for you to read the rest of the notes so they can move on to the next topic in our next class. If there are any questions, we'll deal with them. Okay, no question. All right. For a good night.